Hi, thanks for using my court coach. I'm Sarah and I'll be your instructor today as we talk about the judgment form, also known as form FL-180. As with all our court forms, you want to fill in your identifying case caption information at the top. This judgment is going to serve as the final decree on either your dissolution, legal separation, or nullity in your case, so you want to mark the box that correctly identifies what sort of case we're dealing with here. If it is a dissolution and it's a status only, meaning we're just terminating the marital status of the parties but not dealing with any of the issues of the case, mark the box that says status only. If we are dealing with all the issues of the case except for the termination of marital status or domestic partnership status, then you would mark the box below that. If there was a judgment previously submitted that dealt with some of the issues of the case but not all of them, and this judgment is intended to deal with the remaining issues, mark the box that says judgment on reserved issues. If it has been at least 6 months since the respondent was served with the petition and or appeared in the case, then you can select a date that you want the marital status to end on in the future. For instance, if you want to ensure that this judgment is not entered until the following year, perhaps for tax filing reasons, you could list a date that you want the marital status or domestic partnership to end. Otherwise, you can leave that blank, and when this judgment is processed by the court clerk will fill that in. If there are any sort of restraining orders that are related to this case and they are contained inside the judgment or the judgment intends to modify those, mark the box 1 and indicate whether we are including personal conduct restraining orders or modifying them in the judgment, and state the name of the page number of the attachment that can be found on and the expiration date for those restraining orders. Otherwise, you can leave line 1 blank. Line 2 indicates how this proceeding was heard. If this is a default or an uncontested judgment, then you would mark the box that says default or uncontested. If it is contested and there was a trial, mark the box that says contested. If there was an agreement in court, then you perhaps a stipulated agreement that was read onto the record, mark the box that says agreement in court. For uncontested, you can do by declaration. I generally don't mark this box though, and I wouldn't advise doing so. Again, if this stemmed from a trial or a hearing, then you want to list the date, department, or room number where that hearing took place, as well as the name of the judicial officer who heard the case. If there was a temporary judge hearing the matter, mark the box that says temporary judge. And then you want to identify all the parties that were present at that hearing or trial. Below that, you want to mark the box that reflects the date that the court acquired jurisdiction of the respondent on. It can either be the date that the respondent was served, or it can be the date that the respondent appeared if they appeared within 30 days of service. And so you would list that date there. If we are asking for a divorce, then you want to mark box 4A, judgment of dissolution, and that's going to terminate either marital status or domestic partnership status. And if you have a specific date in mind, again, as we discussed about above, you can list that specific date. If you're leaving this up to the court to determine once they process this paperwork, then mark box 2 and they will fill in the date. If this is a judgment of legal separation, mark box 4B. If this is a nullity, mark box 4C. If this is a request to make a judgment nunc pro tunc, list the date that you want them to make the order nunc pro tunc to. What that means is if there has been a mistake or based on mistake, negligence, or inadvertence, and the original judgment was set aside, then the court has the ability to make a retroactive order as to the date the judgment is entered into. But it can only be if there was a mistake, negligence, or inadvertence, or that the judgment was not entered as soon as it could have been entered into under the law if applied for. Again, if this is a judgment on reserved issues, mark box 4E. If either party is requesting that their former name be restored, mark the box that identifies the party that's asking for the name change and list the full name that they are asking it to be changed to. I always include first name, middle name, last name. If this is perhaps a status-only judgment, you want to mark box 4G, and that's stating that the court is going to reserve jurisdiction over all other issues that are not being addressed in this judgment, meaning that they can go back and make those decisions at a later date. It doesn't necessarily have to be a status-only judgment. If this judgment is a partial judgment and it only contains resolution of some of the issues, but not all of them, you would also mark 4G. If this judgment does include orders for child support or family support, mark box 4H, and this also just notifies the parties that a child support case registry form, that's the form FL-191, needs to be filed with the court within 10 days of the date of this judgment, and also that any sort of orders regarding child support should also have that notice of rights and responsibilities form FL-192 attached. Regardless of whether custody orders or child support orders are being made via this judgment, if there are children of this relationship, you want to mark box 4I and then list the name and birth dates of those children. If you need to attach a separate sheet of paper and there's not enough space here, you can go ahead and do so. If any of the children of this relationship were born prior to the marriage or domestic partnership, mark box 4-2, I2, and that indicates that we are establishing parentage for those children. If this judgment contains child custody and visitation orders, you want to mark box 4J, and then you refer to the court to either the written agreement that's attached to this judgment or the child custody and visitation order attachment, FL-341, and that can also include FL-341 A through E. Those forms have very specific provisions regarding custody visitation included in them, or referring them to the stipulation and order for custody and or visitation of the children. Or if it's been previously established in another case, you would want to mark box 4J4 and list the case number and court for those custody orders. If there's child support being ordered as a part of this judgment, again, same thing. We are either going to refer the court to the written agreement that's attached to this judgment, the form, in this case, it's going to be the FL-342 form, the child support information and order attachment, or a stipulation to establish or modify child support and order, that's the FL-350, or if it's been established in another case, then you want to mark box 4K4 and list the case number and court where that case is being handled. If there are orders for spousal support in this case, we are going to, again, if there's a written agreement, we're going to mark the box that refers to the court to the written agreement. If there is an attachment, one of the forms that we're using, we're going to refer the court to that attachment, and that is going to be your FL-343, your spousal partner or family support order. If we are asking the court to make an order to either terminate or reserve over spousal support to awarded to either party, mark box 1 or 2 here. If there's any other orders regarding spousal support that we are referring the court to, then you want to mark other and identify what that is. Property division. If there are orders regarding property division as part of this judgment, mark the box M. And again, we are either going to refer the court to the settlement agreement that's attached to this, the form FL-345 that you can use in lieu of that, that's the property order attachment to the agreement, or any other documents. You would mark M3 other and specify what those documents are. And finally, attorney fees. If there are orders regarding attorney fees, then we would want to mark the box N and again refer the court to the written agreement, the form, which is FL-346, attorney fees and costs order, or if there's any other documents, mark box N3 and list what those documents are. If there's any other orders that are not specified above that you want to draw the court's attention to, mark O, other, specify. Oftentimes, if there is a written agreement, I refer the court to the written agreement. I say see marital settlement agreement or see attached agreement. Leave the judicial officer line blank, the date blank, if there is an agreement, and most likely there are attachments to this form. List the number of total pages attached. And then this form gets attached to your judgment forms that you're submitting to the court. And once the judge signs this, it becomes an official order of the court and an official decree either divorcing you, granting your legal separation, or granting your nullity. I hope you found this helpful. Good luck.